will hear arguments this afternoon in Counterman v. Colorado. Mr. Luke, you may proceed whenever you are ready.
Thank you, Madam Chief Justice, and may it please the Court. My name is Mr. Luke, and it is my pleasure to represent the petitioner in this very important case. The United States government, in its current state under most circumstances, cannot restrict, censor, or punish a person's speech per the First Amendment. Specifically, the amendment reads, Congress shall make no law abridging the freedom of speech. Under certain circumstances, however, the speech can be limited. Reasons for a limitation can have to do with the protection of public safety, such as an individual yelling fire in a densely populated area when there is no real threat present. The content of the speech is not what is restricted in most cases, for the effects it warrants is restricted. Furthermore, slander, libel, and truth threats are restricted strictly based on their content. Focusing on truth threats, it was never rigidly defined by this court, but it is not protected by the First Amendment anyhow. This offense can become a crime if the threat was meant to injure or kill another. As ruled in Virginia v. Black, precedent case, a truth threat also includes statements in which the speaker purposely puts forth a serious expression of a plan to commit unlawful violence. Importantly, however, laws restricting speech must be well-defined and narrowly limited, as determined in Watts v. United States. Moreover, there are two ways to determine a truth threat, which sparks controversy. A subjective test includes a determination of whether the speaker aimed to or knew that the recipient would feel threatened. On the other hand, an objective test focuses on the language and the context of the specific threat, and if the recipient would feel threatened or frightened by the speech if they are a reasonable person. In regards to the case at hand, Billy Counterman, over a period from 2014 to 2016, sent CW, a professional female musician, a series of direct messages on the platform Facebook. The messages were mostly memes and quotes, but could sometimes include messages that were reportedly garbled, rambling, and delusional. These messages in particular caused CW to feel threatened and indicated that Counterman knew her, as well as his signs of mental illness. CW's professional Facebook has a system in place which automatically accepts all friend requests, since strangers commonly request her. This allowed Counterman to friend her again, for he made another account which was automatically accepted, therefore allowing him to message her. One message from Counterman that led CW to believe she was following her included him mentioning her white Jeep, which she previously owned. Two messages from Counterman read, Your arrogance offends existence of anyone in my position. Friend are you? You have my number. Say, I'm not avoiding you. That was opt. You're not being good for human relations. Die. Don't need you. And staying in a cyber life is going to kill you. Come out for coffee. You have my number. The latter was sent several weeks after the former, and CW felt these messages were becoming increasingly aggressive over time. Reportedly, CW was canceling shows, withdrawing from public appearances, declining engagements, and having panic attacks due to the messages, which she said had a negative impact on her career. For her safety, CW filed a restraining order against Counterman, which states he shall not contact her, but she was never served it by law enforcement. Regarding the mental health of Counterman, as discussed before, he was previously diagnosed as, in fact, having a mental illness. While he has been convicted in the past for threatening communication due to his mental illness, he did not intend any messages to be threatening and clearly did not understand that CW felt the way she did. Counterman also states that he thought she was messaging CW on other sites and Facebook pages. Communications through telephone and in person were never attempted by Counterman, with communication only being through Facebook. After CW's restraining order, Counterman did not attempt to contact her again, yet he was still arrested. He was charged for making a credible threat, acting with intent to harass, annoy, or alarm, and knowingly, directly or indirectly through another person, repeatedly contacted or made any form of communication in a manner that would cause a reasonable person to suffer serious emotional distress, and did cause serious emotional distress. Evidence and testimony about Counterman's mental health and intentions were excluded by the trial court. The first two charges were dropped, but he was convicted of the third and sentenced to 4.5 years in prison. Counterman appealed to the Colorado Court of Appeals, which stood with his sentence and conviction, finding that the court was correct in using the objective test for truth threats. The test included the jury to state if they found Counterman's messages would cause a reasonable person to suffer serious emotional distress. Yet again, Counterman's intention and awareness of the threatening nature of the messages were excluded. The Colorado Court of Appeals, according to Colorado law, stated there are several factors to be considered when a threat is communicated online. They are 1. The statement's role in a broader exchange, if any, including surrounding events. 2. The the medium or platform through which the statement was communicated, including any distinctive conventions or architectural features. 3. The manner in which the statement was conveyed, for example, anonymously or not, privately or publicly. 4. The relationship between the speaker and the recipients. Finally, 5. The subjective reaction of the statement's intended or foreseeable recipients. So, to determine if a statement is a true threat, which is unprotected by the First Amendment, the government should show the speaker subjectively knew or intended their statement to come across as threatening. It is not enough to determine a statement's true nature solely by the objectives that a reasonable person would find it threatening violence. Counterman, in the state in which he sent the messages to CW, was mentally ill and believed he was having a conversation with her through other platforms. In the cases previously regarding this issue, the evidence just stated was not allowed to be submitted to the court. In other words, Counterman had no idea his conversations were all one-sided. Counterman did not recognize the threatening nature of his messages, which furthers the need for the test of the statement, which recognizes his intent and knowledge of the challenged threatening nature of the message. Supreme Court precedents have used the speaker's intent in similar situations as this. For example, the court in the case of Virginia v. Black stated a true threat was, and I quote, where the speaker means to communicate a serious expression of an intent to commit an act of unlawful violence to a particular individual or group of individuals. In addition, the use of an objective test, the test used to determine Counterman's statements in the previous courts, excludes nonverbal cues, which could help the recipient understand the context the statement is being said. Objective tests also increase the likelihood of criminalizing simple misunderstandings, exaggeration, and artistic expressions. In conclusion, the use of objective tests can strike fear in people and therefore prevent them from expressing unpopular political beliefs or minority religious beliefs in fear of being prosecuted. To determine if a statement is a true threat, it must go through a subjective test, where the speaker's intent and knowledge of the particular nature of the statement is included in the determination to avoid misunderstandings, persecutions, and to prevent the criminalizations of messages that are not intended to threaten others.
What about fighting words? Are they protected by the Constitution? You will need to look outside the packet and look at a precedent case.
According to Chaplinsky v. New Hampshire, fighting words are not protected by the Constitution. In the case, Walter Chaplinsky, a Jehovah's Witness, distributed religious pamphlets and spoke one afternoon in Rochester, New Hampshire. When Walter was speaking, a crowd gathered around him as he spoke against organized religion, and the crowd became restless. A city marshal reminded the crowd that what he was saying was within the law, but after the marshal left, he received word of a riot sparking. When he headed back, the marshal saw Chaplinsky being escorted to a police station. When Chaplinsky saw the marshal, he said offensive words saying that the marshal was a racketeer and the government of Rochester were fascists. These words were not protected by the Constitution, and Chaplinsky was soon arrested, violating a New Hampshire law that prohibited the use of offensive, derisive, or annoying words toward others or preventing them from going about their lawful business. Chaplinsky did appeal, arguing the state limited his First and 14th Amendment speech freedoms. When the case went to the Supreme Court, it was a unanimous decision which held that certain words spoken or written are exempt from the First Amendment protection when they initiate violent reaction by listeners. Even though most speech is under the protection of the First Amendment, expressions that are lewd and obscene, profane, libelous, and insulting or fighting words cannot claim constitutional protection. Justice Francis W. Murphy also added that whenever speech does not contribute to the expression of ideas or possess any social value for the truth, the right to utter that speech can be limited by government when it seeks to promote the social interest in order and morality. To conclude, fighting words are not protected by the Constitution, based on the case of Chaplinsky v. New Hampshire. Most expressions are protected under the First Amendment, but not if they are crude, obscene, or derogatory.
Action.
We will now hear arguments from the respondent. Ms. Joyce, you may proceed whenever you are ready.
Thank you, Madam Chief Justice, and may it please the court. My name is Joyce, and it is my pleasure to represent the respondent in this very important case. In the United States, the digital landscape is growing, and with it, online interactions. This country idolizes free speech, yet not all speech is protected under the law. True threats, slander, and libel are all exceptions to this. However, the definition of a true threat has been disputed throughout the course of our country's history. The First Amendment does not protect true threats, and they have always been prosecuted. However, the government usually cannot punish or censor a person's speech. Despite this, a person isn't permitted to say anything at any time. For instance, a person yelling fire when there is no fire could cause panic and start a stampede. In this case, the person's speech can be restricted to ensure public safety. In the precedent case of Watts v. United States, the Supreme Court has previously ruled that true threats must be well-defined and narrowly limited. Additionally, in Virginia v. Black, the court has ruled that true threats are statements where the person making them needs to communicate a serious expression of an intent to commit an act of unlawful violence. There are two tests to determine if speech is considered a true threat: a subjective test and an objective test. There is a conflicted view on which test should be implemented. A subjective test focuses on the speaker's intent of the message and their knowledge of whether the recipient would feel threatened. On the other hand, an objective test is about whether or not the recipient, who is a reasonable person of the message, would feel threatened or frightened by it. The debate is about whether a true threat is when a speaker has the intent to harm or when the recipient of the message has reasonable fear of the harm. This case spans over a 2-year period, from 2014 to 2016. In this time, Billy Counterman sent CW, a professional female musician, hundreds of direct messages on Facebook. According to CW, the messages seemed like they were garbled, delusional, and rambling, which made her feel threatened. She said that Counterman's messages did not make sense, which caused her to believe he was mentally ill. This led her to become concerned for her safety. CW did not interact or respond with Counterman and instead blocked him. She stated in trial that blocking someone was a clear sign and the strongest way to tell someone to stop communicating with you on Facebook. However, instead of ceasing to message CW, Counterman then created several other profiles and sent friend requests to CW. Due to her professional career, CW was used to receiving friend requests from people she did not know personally and had a Facebook feature that accepted friend requests automatically, which allowed Counterman to message CW again. One message from Counterman stated that he mentioned seeing her in a white Jeep. Despite not owning a white Jeep currently, this led CW to become concerned that Counterman was following her. Some of the messages from Counterman read, "Your arrogance offends existence of anyone in my position. Bleep friend are you? You have my number. Say, I am not avoiding you. That was opt. You're not being good for human relations. Die, don't need you. F off permanently. Only a couple of physical sightings. And staying in a cyber life is going to kill you. Come out for coffee. You have my number." The tone in the messages over time made CW feel that Counterman was becoming more aggressive. This began taking a mental toll on her, leading her to decline engagements, have panic attacks, cancel shows, and withdraw from public appearances. These actions adversely affected her career. To prohibit Counterman from contacting her, CW obtained a restraining order, but this was not served by law enforcement. Counterman was previously diagnosed with mental illness and convicted on 10 counts of making threatening communications in interstate commerce, which is a federal offense. He alleged that he never intended to come across as threatening and did not understand that CW had felt threatened. In addition, Counterman did not attempt to contact CW in person or via telephone. But although he didn't try to contact her after the restraining order was issued, Counterman was arrested and charged with 3 counts. 1. Making a credible threat. 2. Acting with intent to harass, annoy, or alarm. And 3. Knowingly, directly, or indirectly through another person, repeatedly, contacted or made any form of communication in a manner that would cause a reasonable person to suffer serious emotional distress, and did cause serious emotional distress. The state of Colorado made a motion before the trial to exclude Counterman's mental state and whether he knew that his messages would cause CW to feel threatened and suffer emotional distress. The attorneys for Colorado cited that it would confuse the jury since the law only requires that Counterman repeatedly communicated with CW. Additionally, the judge granted the motion to exclude the testimony, so Counterman's attorneys could not submit evidence on his intent. The first and second charges against him were later dropped. However, he was convicted under the third charge and sentenced to 4.5 years in prison. Counterman appealed to the Colorado Court of Appeals, which also upheld the conviction. It found that the judge was right to apply an objective test for true threats. According to the Colorado Court of Appeals, there are numerous factors to be considered, especially if the threat is communicated online. 1. The statement's role in a broader exchange, if any, including surrounding events. 2. The medium or platform through which the statement was communicated, including any distinctive conventions or architectural features, the manner in which the statement was conveyed. For example, privately or publicly, anonymously or not. 4. The relationship between the speaker and the recipient or recipients. And 5. The subjective reaction of the statement's intended or foreseeable recipient or recipients. The Colorado Supreme Court denied review, and the U.S. Supreme Court agreed to hear the case. Counterman's messages to CW are true threats under an objective test. Threats express a serious intent to commit physical violence which causes harm to the recipient, and regardless of the speaker's intent, causes harm that affects the recipient and does not in any way contribute to the marketplace of ideas. Using a subjective test in this case would not account for the harm the true threat causes in the recipient, no matter the speaker's mental state. CW was clearly affected by Counterman's messages. She had panic attacks, canceled shows, withdrew from public appearances, and declined engagements. This took a toll on her career, an adverse effect of Counterman's threats. Despite having a mental health condition, Counterman could be just as capable of inflicting serious harm. Even if he had no intention of causing CW harm, the damage he has caused is all the same. Moreover, threats have been punished in the past regardless of the speaker's mental state. As seen in Watts v. United States, the Supreme Court focused on the context of the claims rather than the speaker's intent. These true threats are unprotected by the First Amendment because of the damage they inflict upon the recipient. The court's previous rulings have all used a contextual inquiry over intent, and so this standard matches precedent and tradition. An intent-driven inquiry is less effective than a contextual inquiry because by just focusing on the intent of the speaker, the victim's harm is ignored. Furthermore, a contextual inquiry can also protect those who have used poorly chosen words without chilling valuable speech. When using this context-based inquiry, Counterman's conviction satisfies this. A contextual inquiry allows for free expression while also protecting victims from fear of violence and the adverse effects fear has in their life, as seen in the disruptions and fear Counterman inflicted on CW and her life.
Who is the reasonable person? I mean, would it just, as we might say in the Fifth Amendment context for custody, is it kind of a general reasonable person? Say, if something happens on a college campus, is it the reasonable college student, which might be different? Well, that's not quite what I'm asking, because I can look at a college classroom, say, or a law school classroom, and I can say, if Justice Gorsuch or I were sitting in that context, let's imagine a professor who wants people to understand just how vicious it was to be in the Jim Crow South and puts up behind them on a screen a picture of a burning cross and reads aloud some threats of lynching that were made at the time. A purely educational purpose in the teacher's mind, but students feel physically threatened.
We believe the reasonable person is CW because she is of sound mind. CW is the reasonable person because she has no mental illnesses, unlike Counterman. Counterman is clearly unstable, and when County has multiple convictions of threatening communications and its delusional messages, having someone send threatening messages know certain information about you, and being stalked is objectively terrifying to anyone, providing CW reason for her concern.
I just want to clarify just so that I can be sure I understand. So you were talking about the reasonable person, and is your standard the reasonable person in that situation would have perceived the statements as a threat? Is that what you're saying about the reasonable person?
Yes, we believe that a reasonable person would have understood these communications as a threat. Counterman sent a message to CW that mentioned seeing her in a white Jeep. Even though she no longer owned the white Jeep, she had at one point, and knowing that Counterman knew so much about her life was objectively terrifying to her. This was enough evidence for her to believe she was being stalked and she may be in danger. We believe that many people would have felt threatened in her position, proving that her perception of the events that occurred online was reasonable and justified.
We will now hear the rebuttal from the petitioner. Mr. Dillon, you may proceed whenever you are ready.
To begin, there are two types of tests to take into consideration: an objective test and a subjective test. A subjective test focuses on the intent of the threat from the speaker, while an objective test focuses on the content of the threat. While the respondent may claim an objective test should be used, in this situation, a subjective test should be used instead. Based on Counterman's medical conditions, even if his words had seemed threatening to CW, he did not know the impact of his words. Because of this, Counterman should not be negatively impacted, since his illness would affect his ability to think through the messages he was sending CW. Counterman was clearly mentally ill, and it was not his intent to send the threatening communication to CW. The respondent may claim that true threats shut down the recipient's speech and inflict harms upon them. However, this was not a true threat because Counterman, being mentally ill, thought he was simply having a conversation with CW, instead of threatening her or attempting to negatively impact her career. For example, in the court case Virginia v. Black, the state of Virginia had a law that banned burning a cross with the intent to intimidate others, which was permitted by the First Amendment. Eventually, the court ruled that it is possible that burning a cross could be a political or expressive activity, and without the intent to intimidate others, it would be protected by the First Amendment. Additionally, the court also said that a true threat is where the speaker, in our case Counterman, means to communicate a serious expression of intent to commit an act of unlawful violence to an individual or group of individuals. Distinctly, Counterman was mentally ill, meaning there is no possible way that he could have had any intent whatsoever to commit an act of unlawful violence against CW, especially considering that he wasn't even talking to her for the entire time online. In addition, CW accepted all friend requests on Facebook. The respondent may claim that true threats cause fear for the recipient's physical safety, disruption of their lives, etc. However, CW failed to take measures to turn off the feature that auto-accepted friend requests. Moreover, the respondent may claim that threats made by people with mental health conditions are just as capable of causing serious harm, and that CW didn't respond when Counterman contacted her. However, as a singer/songwriter on social media, CW should be prepared to face negative comments and be able to ignore them. Furthermore, for instance, in the court case Alanis v. United States, Anthony Alanis posted rap lyrics to his Facebook page that contained language which terrified his ex-wife. After the FBI visited him, he posted lyrics about his thoughts of killing the FBI agent and her family if he was arrested. The FBI arrested him and charged him with a felony under a federal law banning interstate threats. The case was taken to the Supreme Court and ruled for Alanis. The court decided that in order to convict someone under the federal law, more would have to be proven than just if a reasonable person would have been threatened. A majority of the people said that wrongdoing, in this case Counterman, must be conscious to be criminal. Clearly, Counterman's wrongdoing was not conscious if he was mentally ill. Finally, as mentioned in the court case, Counterman kept contacting CW multiple times, even though she didn't answer. Because he was mentally ill, he didn't recognize that the person he was sending messages to on other platforms wasn't CW, and therefore kept contacting her. This directly shows that Counterman thought he was talking to CW when he wasn't, making it very clear that he was mentally ill and therefore did not know the threatening nature of what he sent CW.
We will now hear the rebuttal from the respondent. Ms. Nina, you may proceed whenever you are ready.
Petitioners may claim that due to his mental illness, Counterman did not know his conversations with CW were one-sided, and that he believed to be communicating with her through other social media platforms. However, the evidence does not support this claim. CW never responded when Counterman contacted her, and after blocking his number several times, it was clear that CW was uncomfortable with the communication. Facebook was the only platform that Counterman ever contacted CW on, and despite being blocked multiple times, he continued to create false accounts. Petitioners rely heavily on the basis that Counterman was mentally ill. However, in this case, we are strictly looking for the definition of what factors warrant a true threat. The mental health of the predator does not negate the threat. For example, the text states, "Threats made by persons with mental health conditions are just as capable of causing serious harm." The severity of Counterman's threats negatively impacted CW's career and mental health. This text also reads that true threats cause fear for recipients' physical safety, disruption of their lives, and silence their speech regardless of the mental state of the person making the threat. Whether the person making a threat intends to cause harm, the damage is the same. Counterman makes claims such as, "Your arrogance offends existence of anyone in my position." "Leap, friend, or you. You have my number. Say, I'm not avoiding you. That was opt. You're not good for human relations. Die, don't need you. F off permanently. And staying in the cyber life is going to kill you. Come out for coffee. You have my number." These threats continued to become more hostile and concerning over time. His delusional behavior is threatening in and of itself, and when combined with the persistence of his messaging, CW was rightfully alarmed. The fact that he was privately contacting her, rather than on her public page, also contributed to CW's discomfort. His vague and cryptic messages leave his intent up to interpretation, and one could question whether the vagueness was calculated after considering his 10 prior counts of making threatening communications. In the span of 2 years, Counterman had sent hundreds of messages to CW with no response. As a celebrity, it is important to understand that negativity that some fans may express. However, as the aggressive behavior from Counterman only increased, CW saw it necessary to take more precautions. As Counterman expressed his knowledge of the white Jeep that CW had previously owned, and with the message pertaining to meeting up for coffee, it provides an example to the possibility that Counterman was planning on meeting CW in person in the future. With the information that Counterman had known about CW, he is capable of inflicting harm through the sheer persistence, pattern, and lack of clarity in his messages. CW also claimed that Counterman seemed out of touch with reality, and that his messages were garbled and rambling, which led to more concern. Due to this, there is no way to prove that Counterman's intentions would not lead to physical harm. The present case, Watts v. US, focuses purely on the content of the threats, not on the mental or emotional state that may have been placed on both the sender and the recipient, which places emphasis on how the quantity of messages over a certain period of time could be used as a determining factor of the threat. Most importantly, and in conclusion, when specifically looking strictly at the facts, Counterman's communication escalated in aggression and persistence over the 2-year span when he sent hundreds of messages despite being blocked. He created multiple false accounts to continue the confrontation despite her lack of response. This, combined with the previous knowledge of his past convictions and CW's attempted restraining order, proves that his actions did pose a true threat.
We rule in favor of Counterman in a 5-3 decision.